Good afternoon. It's Thursday, February 9th. Legislators just got on the highway to head back to their hometowns. Maybe you'll see them at Cracker Barrels this weekend. This is my weekly update. Not a lot to report because things are moving a little bit slowly right now. The Mineral Trust Bill, House Bill 1081, that's been through the House, approved, and it's waiting to be heard over in the Senate. 1083, which is the filing fee for the Equal Access to the Courts Commission, that has been on the House calendar, meaning floor debate, for 5 straight days, and they stopped one bill short of it, and so they'll take that up on Monday of next week. I'm cautiously optimistic that that's looking okay. House Bill 1080, that's the access to digital assets, that's through the House. The Bar Commissioners that's a uniform law, and the Bar Commissioners authorized us to support that, so that's awaiting hearing in the Senate. House Bill 1053, that's the, if you remember last week, that's the Wall Groton, let small communities participate if they want. That's through the House, waiting to be heard in the Senate. Senate Bills 168, and this says 169, but I think it's 167. Dealing with powers of attorney and guardianships, this is the aftermath of last year's Peter Falk bill. I'm starting to hear from the Real Property Trust probate folks with significant concerns. It's likely that that tomorrow I'll take that to the Bar Commissioners and recommend that, based on the advice that we've gotten, that those be opposed or substantially amended. So this is a stay tuned, and we'll see what happens. Senate Bill 138 was heard this morning in Senate Judiciary. That's some revamping of special procedures for asbestos trust claims. I'm not even sure what happened this morning because I had to be in House Appropriations for the better part of the morning, and so I can't really give you an update. I do know that part of our concerns was a waiver, statutory waiver of attorney-client privilege, which of course troubles all of us. But I heard last night that an amendment was coming to address that, and I didn't have a choice. When the chair of the Appropriations Committee asked to meet with you, then you go do that. So that's what I did. So you'll have to wait for a week, and I'll give you the update on that. Shared parenting defeated on the Senate side. That's now it's reemerged like the phoenix. That'd be House Bill 1203. That's been assigned to Judiciary. On the House side, has not yet been scheduled for a hearing. As I mentioned, the bathroom bill was withdrawn. The House voted a couple days ago that if you've got a permit, you can carry in the Capitol building except for the Supreme Court chambers. And that's, we don't do guns, we don't do abortion, we don't do nuclear disarmament. But on the issue of guns, we do guns if they want to bring them into our courtrooms. But they gerrymandered around in the Capitol so that it didn't cover the courtroom. So we're parked, meaning we didn't take a position on that. What the Senate's going to do, what the governor will do, I don't know. There are a couple adverse possession bills. I mentioned that last week. 1139 is going to be heard on Monday. I'm still waiting to hear back from the Real Property Trust probate folks on whether this is okay or if it is an alteration of better than 1,000 years of English jurisprudence on the issue of adverse possession. It was really interesting. A number of years ago, they were going to repeal it or substantially limit it. And with Professor Hageman's assistance, I did research that took us back 1,000 years. And of course, what we think of as adverse possession today is generally 23 years. But way back during the times of the Crusades, when the Lord of the Manor may leave with his family and they may not come return for 2 generations, they extended the grace time for the family to return and retake over the estate to 99 years. And depending on what was going on in the world back then, those numbers moved all around. It was really fascinating. In any event, they're looking at it. I'm hoping that we'll have some recommendation from them to give to the bar commissioners tomorrow afternoon. The last thing I'll mention is that, as you may recall if you've been following in the newspapers, the excessive delay of sometimes 3, 4, 5, 6 months for a criminal defendant who can't make bond and who's awaiting an evaluation, psychological evaluation. Well, the Chief Justice, with support from the Governor's office, formed a task force. They've got a lot of recommendations. They are reflected in House Bill 1183. That just got dropped, hasn't been scheduled for a hearing on the House side. Talking with the Chief Justice, he said may need some help from the bar. That's up to your bar commissioners. Typically we support the Chief Justice on their legislation, but we'll wait and see. So I'll take that to the bar commissioners tomorrow and ask them for permission to assist if needed. I see warm weather's on the way. It arrives tomorrow, and we deserve it. You folks have a great weekend.